I'm Ben Meiselas from the MeidasTouch Network. The Department of Justice just sent a powerful letter to MAGA Republican Jim Jordan, who somehow chairs the House Judiciary Committee, saying that the Department of Justice is ready to put on as a witness in a public hearing David Weiss, who is the Trump-appointed top federal prosecutor in Delaware, the United States Attorney of Delaware, the individual who actually pursued the criminal investigation into Hunter Biden starting in 2018, who effectuated a plea deal with Hunter Biden. And the Department of Justice in this letter said, while it is sometimes not typical procedure for someone like David Weiss, a prosecutor, to testify before a House of Representatives committee while charges and while a criminal investigation is still pending. The fact that MAGA Republicans have lied over and over again about David Weiss, have misrepresented his positions, have stated that he was obstructed in his criminal investigation, when David Weiss is saying, I wasn't obstructed at all. I had total control over the criminal investigation into Hunter Biden. In fact, when David Weiss asked Merrick Garland if he could get what's called special attorney status to allow him to prosecute Hunter Biden if necessary in other states where David Weiss may not otherwise have jurisdiction of, because Weiss is only the United States attorney in Delaware, Merrick Garland said, fine. Do whatever you want to do. You could have special attorney status in any state where you believe there are crimes. DOJ, Washington, D.C. is not going to interfere at all with your criminal investigation and criminal case. But that didn't stop the MAGA Republicans from holding a hearing last week where they brought in fake whistleblowers, a guy named Gary Shapley, and another person named Joseph Ziegler. And these individuals went up there and they said, oh, we were delayed. We were obstructed. The investigation was hamstrung. The investigation was not allowed to take place. And then during questioning and cross-examinations by Democrats, it turns out that a lot of the things MAGA Republicans were saying that was obstructive of David Weiss's investigation of Hunter Biden, like it took place when Donald Trump was in office. And again, David Weiss is a Republican. He is appointed by Donald Trump, the prosecutor. Joe Biden was well within his rights to fire all of the United States attorneys when Biden took office. That's the normal standard procedure, including David Weiss. But President Biden said, we don't even want the appearance of impropriety. So while it is typical for a new administration to fire all the top prosecutors in the prior administration, Biden's like, you know what? I'm going to let the Trump-appointed prosecutor continue to go after my son because I don't want the appearance of impropriety here. So that's one of the only United States attorneys that Biden's like, I'm not going to fire. But even doing that, the MAGA Republicans were like, oh, you've weaponized the DOJ. Oh, you've done this or that. And here in this letter, the DOJ is like, all right, we're going to bring David Weiss in. We want it to be a public hearing, and David Weiss will testify. So here is the letter to Jim Jordan. The Department of Justice, U.S. Attorney writes the following. Dear Chairman Jordan, this responds to your letter to the Attorney General dated July 21, 2023, expressing continued interest in an individual ongoing criminal investigation and prosecution led by the U.S. Attorney for the District of Delaware, David Weiss. The Department of Justice appreciates the Committee on the Judiciary's acceptance of our offer for U.S. Attorney Weiss to testify at a public hearing before the committee. The department is ready to offer U.S. Attorney Weiss to testify shortly after Congress returns from the August district work period, as described more fully below. Across administrations, the department has long recognized its obligations to protect law enforcement work from even the perception of political interference, including from Congress. Our long-standing principles and duty to take care that the law be faithfully executed requires us to maintain the confidentiality of sensitive law enforcement information and to protect line attorneys and agents so that they can do their jobs for the American people, free from improper political pressures. These concerns are heightened while a matter is open and investigative steps, prosecutorial decisions, or judicial proceedings are ongoing. At the same time, we are deeply concerned by any misrepresentations about our work, whether deliberate or arising from misunderstandings that could unduly harm public confidence in the even-handed administration of justice to which we are dedicated. The department therefore reaffirms U.S. Attorney Weiss's commitment to providing public testimony consistent with the law and department policy to protect these principles. So right there, the Department of Justice is saying, well, we need to bring David Weiss here, even though we need to protect confidentiality. The public trust is important, and we are deeply concerned about misunderstandings, whether you are doing it intentionally, Jim Jordan, or it's just a misunderstanding that you are engaging in this. I mean, they're saying that kind of like tongue-in-cheek here. They know that he's doing it intentionally, but they're kind of calling him out eloquently here. But they're saying, okay, he'll tell the truth, and we'll put him up there just to rebut your lies. The letter goes on to say, your letter refers to assertions made by two Internal Revenue Service investigators regarding U.S. Attorney Weiss's authority and asks additional questions about U.S. Attorney Weiss's recent letters explaining the scope of his authority. By the way, notice how they don't call them whistleblowers in the letter. U.S. Attorney Weiss is the appropriate person to speak to these issues, as he is both the senior departmental official responsible for the investigation, as well as the person with direct knowledge of the facts necessary to respond to the assertion in which you have expressed interest. The department believes it is strongly in the public interest for the American people and for Congress to hear directly from U.S. Attorney Weiss on these assertions and questions about his authority at a public hearing. To address these issues, U.S. Attorney Weiss is available to appear at a public hearing before the committee consistent with the law and department policy after the House returns from its August district work period. U.S. Attorney Weiss is available on September 27th, September 28th, October 18th, and October 19th. To be clear, the most appropriate time for any testimony on these subjects is after the matter is closed, especially under circumstances where the matter is pending before a court and subject to judicial supervision, not to mention legal and ethical bars that limit what the department can say while the matter is pending in court. While testimony at this early juncture must be appropriately limited to protect the ongoing matter and important confidentiality interest, the department acknowledges your stated interest in addressing aspects of this matter in the near term, such as U.S. Attorney Weiss's authority and jurisdiction to bring charges wherever he deems appropriate. It goes on to say, as the department has repeatedly stated, we remain committed to working with you to address the committee's expressed interest consistent with the department's duties and policies. Expressed interest, they're saying. We know what you're really up to here. We are therefore deeply concerned by your notification today that the committee has authorized deposition subpoenas for individuals identified in your letter. Any attempts at compulsory process are unjustified and premature. The committee authorized subpoenas less than a business day after your July 21 letter, and before stated deadlines in that letter. It has been less than a month since the committee's original request, and a little more than a week since the department responded to that letter on the date requested by the committee. During a staff discussion last week, the department and committee agreed to continue discussion. Such discussions would ensure we understand the committee's interest and that you understand the department's longstanding approach across administrations regarding such requests, including those that seek information about ongoing aspects of our work and testimony from line personnel. We remain available to discuss your interests further. We hope this information is helpful. Please do not hesitate to contact this office if we may provide additional assistance regarding this or any matter. Signed by the Assistant Attorney General Carlos Uriarte, United States Department of Justice. I want to show you, though, too, Congressmember Krishnamurthy's cross-examination of those fake IRS whistleblowers, where he's like, you are complaining about things that happened when Donald Trump was in office. Who was the president then? And these fake whistleblower witnesses of the MAGA Republicans can't answer the questions. Here, play this clip.
You were concerned about the complexities of the election cycle and potential delays that arose in connection with the election cycle. You said at page 23, and I remember there were always times where we were always on an impending election cycle. It was always the elections being brought up in early 2020. It was the presidential primaries. Now, sir, Joe Biden was not the president at that time either, was he?
I mean, the answer to your question is no, he was not, but I don't see where you referenced it in my, for me to
Page
follow
23.
along.
You're talking about how the election cycle is delaying decisions by the prosecution. And it turns out that the delay in the election cycle was happening at a time when Joe Biden was not the president.
I'm sorry, sir. That's in Special Agent Ziegler's transcript. That's why I couldn't find it.
So, Mr. Ziegler and you shared concerns about delays related to the election cycle, but at that time, Joe Biden was not the president.
I believe at that time he was the nominee for president.
But, well, he was not the president, was he? It's just a simple question, sir.
Can you rephrase what time period?
Joe Biden was not the president in the presidential primaries in 2020.
Correct. That is correct.
Sir, finally, Mr. Shapley, you said that warrants were ready as soon as April 2020 to begin searching for records, but actions weren't taken with regard to those warrants. Again, Joe Biden was not the president in April 2020, was he?
So I'm confused by your line of questioning. We're talking about an election to which now President Biden was a part of. So he didn't have to be the president to have election meddling.
No, but the question is this. Was he the president at that time in April 2020?
It's been asked and answered.
And what's the answer, sir?
The election.
The answer is
issue
yes or no.
is no.
Thank you.
And,
Thank you. I yield back.
Mr.
Such a powerful cross-examination there by Democratic Congress member Raja Krishnamurthy, who, by the way, we're going to do an interview with him soon here on the MeidasTouch Network. I'm going to be excited to share that with you as soon as we conduct that interview. But there you have it, folks. Powerful letter by the Department of Justice, powerful cross-examination by Democratic Congress member Raja Krishnamurthy, and we will keep you posted, of course, when this testimony by David Weiss takes place. Maybe we'll even broadcast it live here on the network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out. Patreon.com/MeidasTouch. And also wherever audio podcasts are available, subscribe to the MeidasTouch podcast. It's free. And subscribe right now to our YouTube. It's free. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.